Well, we'd like to welcome everyone to the My Horse University and eXtension Horse Quest live webcast on sales fraud in the horse industry. Our presenter for this evening is Julie Fershtman. Julie is with the law firm of Foster, Swift, Collins, and Smith, and is one of the nation's best known and most experienced equine law practitioners. She has successfully tried equine-related cases before juries in 4 states and has achieved numerous courtroom victories. She is the author of 3 books on equine law and more than 250 articles published in magazines across the country. She graduated from Emory College and Emory Law School. I'd like to please note that you can ask questions during the presentation via the chat at the bottom of your screen, and I'll make sure that Julie sees your questions. And there will also be time at the end of the presentation for additional questions as well. So at this time, I'm going to turn the presentation over to Julie.
Okay, I hope everybody can hear me. And let me get started. I can't hear myself speak, so I am drawing the assumption you can hear me. Thank you all for being here this evening. The topic that I've been asked to speak on is a topic that I hope you'll find interesting, and I'm hoping that none of you has had any bad experiences on your own with equine-related sales. But as an attorney with plenty of years of experience, I can tell you that the problem of difficulties, complexities, legal disputes in equine sales is still pretty much with us. And what you're looking at is actually me. I've been a lawyer for 28 years, and if I were a horse, I suppose that makes me something like the old gray mare, the old dark mare that you see on the screen there. That would be me, and with 28 years of experience comes a lot of unfortunate stories, but I'll get to them in a little bit. Hopefully the information that you can learn from and hopefully avoid disputes with. This is actually me. Not exactly the old gray mare, but getting there. So why are we here today? We're here because sales disputes do occur in the industry, but before we get started on learning a little bit about them, let me learn a little bit about you. Gwen, I'm going to turn the floor over to you to give everybody one of 2 polls that will get us started. Let's get a sense of who you are. Here's a poll for all of you at your computer to fill out. Tell me who you are and understand that you may very well fit into a couple of these categories. Answer with respect to what you would consider your primary status. We've got educators, we've got horse owners. The numbers are changing. We've got 20% others. My apologies, I don't have you listed there. Trainers, you're not here. Horse dealers, you're not here. You should be here. Let's stop right there, and we could see that the spread is pretty broad. We've got mainly individual horse owners, we've got some educators here, and then others that don't quite fit into the categories. Because I haven't given you a category, I apologize, but I think that given who we have listening in today, there's something that all of you can take from what I'm going to share with you. Gwen, let's get to the next slide. And this is another question for all of you. This is the question about your involvement in equine sales disputes. Oh my, the numbers are changing rapidly. And let's take these numbers. It looks like, well, they're still changing. It's about 50-50 now. My God, it really is. We're at 50-50 based on the responses, although the numbers keep on going. Right now the majority has it, the majority very slightly, that you don't know anybody who's been in an equine sale dispute. Most of you, and 44.44%, do know somebody or have been in an equine dispute yourself. Interesting. So that tells us a little bit about who you are and a little bit about what you know. So Gwen, you can take the poll away and let's move on. So why is it that we're here? We're here because sales disputes do occur in the equine industry. Whether or not you've encountered it yourself, a sales dispute is happening and has happened to many, many people in the industry. Let's go through a couple of examples. These have really occurred. First, the problem that commonly occurs, the seller can't provide registration papers. And it's a common problem because maybe the buyer hasn't confirmed the papers exist before the sale occurred. Maybe the buyer hasn't demanded to see them before making payment. Or maybe the seller hasn't made clear in the advertising that the horse doesn't have registration papers, or it doesn't have transferable papers. That's a common dispute. Here's another one. I hope you like the graphics that I've got here. The one on the left is priceless. And that is, let's click a little bit more. Training and disposition are misrepresented, or the allegation is that the seller failed to fully set forth histories about the horse's training or lack thereof, or misrepresentation with respect to the horse's disposition. Just love that picture of the mare on the left. And the problem often is that the buyer makes assumptions about the horse's training. The horse is advertised as registered with tremendous lineage, great pedigree, but that doesn't say anything about the horse's training, or that the horse's dam or sire was a grand champion, world champion, what have you. The assumptions then come to the buyer that with that type of parentage, the horse must have great training. No, it doesn't. And this is a problem because the buyer has simply not sought enough information, or the seller in an advertisement might actually say that the horse is professionally trained. But what does that mean? Does it mean that it was imprinted as a foal and left in a pasture for the rest of its life? The buyer makes assumptions, or the seller isn't being completely clear. Sometimes you'll see that the horse has vices. The horse is cribbing. I take that to mean wind sucking. Or the horse stall weaves, kicks out at the stalls, at the stall walls. All sorts of things that people would consider vices, but the seller hasn't disclosed it, and maybe the buyer hasn't asked about it, or the seller dares to put in an ad, no bad habits. Things like this can occur. Training and disposition are alleged to be misrepresented. The buyer says, I got a bum rap, but this can be prevented, as we'll learn. Here's another dispute. I love these graphics. Sometimes the horse is smaller or larger than represented. I've received many calls from people who are concerned that the horse was larger than represented. That may not be a problem except if the horse is a miniature horse, where size can make a huge difference in terms of the classification, the areas in which the horse can show. You get the idea. Size makes a huge difference. So with that, these problems you can pretty much expect occur when the horse doesn't even have a representation. The seller hasn't made a representation about the size of the horse. These problems occur when assumptions again are made. But there have been instances where the horse is represented in writing to be, say, 15-2 hands when it's really only 14 hands. These things can occur. With a written agreement, not so frequently. Here's a very common problem. Take a look at the screen now. The horse may have been drugged during the buyer's evaluation to mask lameness or other problems. This is a very common accusation that buyers have made to sellers in the industry. I tried a case, in fact, a few years ago. I represented the buyers of a horse and took the case to trial. And in that case, the buyers insisted, my clients that is, that the horse that they tried out in a very busy arena during a show was behaving beautifully. In fact, there were distractions, all kinds of things were happening, and the horse was just unflappable. This was the perfect kid-safe horse that they wanted for their 11-year-old daughter to ride and show, except when they took it home. Within a matter of 2 days, this horse turned into the holy terror. It was a totally different horse than the horse that they rode in that test arena. We tried that case. What does that have to do with drugging? Quite a bit. Because even though no drug screen was done before the purchase of that horse, a veterinarian testified under oath that to a reasonable degree of veterinary certainty, this horse probably was drugged because of the tremendously huge differences in the behavior displayed at purchase to 2 days later. So drugging can be a problem, and I find that to be an accusation that's frequently made, but it's preventable. Let's continue. You really can. You can help prevent many equine sales disputes. You can't prevent all of them, and I know we have at least one lawyer, a friend of mine on this listening in on this webinar, and she would agree with me that even with the best of contracts, equine sales disputes have occurred and they can occur. But with preparation and with advanced planning, you can help prevent many equine sale disputes from occurring. And how do you do that? Well, let's get started, and they're off. We've got quite a bit to cover, and the plan that we're going to have today is I'll keep going and going through quite a bit of information to share with you until about 7:40, and then we'll have about 20 minutes of Q&A, and then I turn back to MSU, Gwen Sheely, and she'll wrap up and make a few more comments about what comes next with the next webinar. So what we're going to discuss? First, how horse sellers can avoid disputes, and then I'll shift over to buyers, how they can avoid disputes. And then we'll get to your questions, as I've mentioned. Keep in mind, when I talk about avoiding disputes, I can't guarantee that the suggestions that I'm going to share with you today will completely prevent all disputes from occurring, but they can make a difference. So let's get going. Let's start with horse sellers. How a seller can avoid a legal dispute? First, advertisements. What do I mean by that? Well, take a look. Chances are you've seen some of these websites. Maybe you've bought horses or sold horses on them. The common ones are dreamhorse.com, equine.com. A lot of these sites are responsible for a huge amount of sales in the horse industry. So what does advertising mean, and how can you as a seller use your advertisements carefully to prevent disputes? Let's go through a couple of examples. Take a look. First, check for accuracy. In the case I tried a few years ago that I talked about briefly, where we suspected that the horse was drugged, there was an advertisement made about the particular horse that my clients bought, and the advertisement said that the horse was sound and ready to show. Well, frankly, he wasn't. As it turned out, on cross-examination in the in the trial, the seller admitted that they really didn't check to see if that was true. They didn't check to see if the horse was sound, and frankly, there were some issues that he wasn't. They didn't check to see if the horse was ready to show. They just figured, well, he behaved okay. Let's put that in the ad. Putting overstatements in the advertisements would be an absolute certain way to create legal disputes in connection with sales. And the reason is the buyers rely often on what you put in an ad. Lawyers would say that the statements you as a seller put in the ad could qualify as a warranty, depending on the law. So be careful about what you put in your ads and check what you state in your ads for accuracy. Second, don't make half-true statements. If the horse has a history of unsoundness, the last thing you'd want as a seller is to say the horse is 100% sound. Ah, but you, the seller might say, he's sound today, he's behaving great today. That may be true, but he wasn't sound last week. In fact, he was terribly lame and was treated for it. Perhaps you had to inject him. Perhaps he's been on some pretty serious medication. Stating 100% sound as a seller is sending a message to the buyer that he has been that way in the past. As a seller, watch out. That may not be a true statement. It's a half-true statement in my book, because the horse in that example had a history. So be cautious about that. Next, don't oversell. As a seller, don't say no bad habits if you really don't know the horse and you haven't observed it. And that can be an issue because a lot of sellers have a corral, an arena, a pasture just loaded with horses for sale. But they have no idea that the horse that's behaving wonderfully in the pasture is going to do some pretty terrible things in a stall. You put that horse in a 10 by 12, 12 by 12, 10 by 10 stall, and he's going to perhaps crib. He'll be kicking the walls. He'll be charging people who come near him. So if you put in your ad no bad habits, because that's the way he appears in the pasture, watch out, because that may be an overstatement. You really can't vouch for it if you haven't had a chance to evaluate the horse. So again, watch out about statements like that. As I say in the last bullet point here, if you don't know the facts, don't state it. Sellers, if you're going to advertise a horse anywhere, make sure you stand behind everything in that ad. Because if the ad turns out to have incomplete, mainly untrue information, you can expect that the buyer will use that ad against you. So let's move on. Other ways that sellers can avoid disputes. Get it in writing. Sure, you can use a handshake. I don't have a problem with a handshake, but get a contract too. Details really matter. Let me give you some examples that sellers might want to use in your contracts. First, whether you're a seller or a buyer, avoid the one-size-fits-all forms. What I'm not referring to are the forms that are customized for you, the seller, customized for your state law. What I mean is that you may go on a chat forum and ask somebody, hey, can you send me your contract? But what you may find is the contract that somebody sent you had to do with another state's law that doesn't apply to you. It may be a seller-oriented contract, but you're the buyer, and the contract may be missing some really important things. Warranty disclaimers, for example. One-size-fits-all forms are a good starting point from which to build a great contract that can protect you. But be cautious before getting a form when you have no idea where it came from, who it was intended to serve, and of course which state's law applies to it. Don't leave major terms in that contract to guesswork. Quick example, if you're going to put in the contract that the horse is sound, that may be acceptable if you're willing to stand by it as a trainer, or as a seller rather. The buyer, when the buyer sees that you're representing the horse as sound, is going to draw a lot of conclusions from it. So if you're going to put language like that in your contract, make sure that you've specified what you mean by that. Maybe avoid the terms that the horse is 100% sound and say, to the best of seller's knowledge, the horse has never been injured, ill, lame during the time that the seller has owned the horse. Hopefully that's a sufficiently long period of time. Avoid guesswork. Specify buyer and seller. This can be a problem, for example, if you're the buyer, and we'll talk about that a little bit later. That may be, for example, when you don't know who you're even contracting with, and there may be issues of hidden commissions. Specify the price and the payment terms. Frankly, if you asked if I stood by or recommended installment sale contracts, I'd say avoid them. I don't tend to like installment contracts unless you truly know who you're dealing with. And understand too, if you're going to buy or sell on installments where a buyer pays over time, there could be different state laws that apply that you may not even be aware of. Specify the horse. Yeah, you could say that the buyer is buying George, but it would be more specific to say George, whose registered name is blank, foaling date blank, and more details with respect to the horse. Why? Because I've actually received calls, maybe you've heard these things happening, of people who purchased a horse online without ever even seeing the horse, other than a photo. And the horse that comes off the trailer is anything but the horse that they saw in the ad. Buyers in those situations have called my office seeking to rescind the sale. If you can specify the horse with much greater detail, that would help so that the buyer knows what will be coming off the trailer, such as the horse being 15-2 hands instead of 17. Details like that can make a difference. What state law applies? You buying a horse if you're in California from somebody in Oregon? Specify in your contract what state law applies to the transaction. It can make a difference. And by the way, if you're in California, you may be duty bound. The law may require that you comply with the seller disclosure law. That's a law unique to California, Florida, and Kentucky currently. If you specify the state law, follow the state law, but be sure to make clear which one does. Let's go through a few more examples. How sellers can avoid disputes, as is disclaimers. Plenty of sellers think if they use a sale contract that has a as is disclaimer and that language that says we sell the horse as is, where is, with all faults, without any warranties, they're set. They have a free pass. They'll never be sued. But by law in most states, that is not true. The buyer can still sue you for sales fraud despite the disclaimer. Why? There's a body of law pretty universally followed that states that certain claims of fraud cannot be disclaimed away. So watch out, sellers. The as-is disclaimer is a good thing to put in your contract if you want some protection, but it doesn't protect you against everything. Next, have the contract signed properly. This applies with equal force, of course, to the sellers and the buyers. Sure, I give some kind of extreme examples here of a very young kid, maybe not signing a contract, but filling something out. And I have an example here of a drink. What's the point? The point that I make is, let's move to the next slide, no underage signers of contracts. Quick example to share with you. I worked on a case years ago. It was not a sale case. It was a serious horse injury case where a rider became permanently paralyzed from the neck down, falling off of a horse. She wasn't asked to sign, or actually she did sign, a liability release before coming to the stable that day to ride. The problem was she was 16 years old. And when the lawsuit came in, the stable insisted that she couldn't sue. After all, of course, they said, she signed the waiver. But the problem was children, that is to say minors under the age of 18 in most states, cannot sign contracts. The contract was voidable, and of course by the lawsuit that she filed, it was voided. You may find plenty of kids eager to buy your horses, horse sellers, but understand that their parents or their legally appointed guardians must sign the contract, not the kid. Next is is there a buyer or seller's agent? Who are you really dealing with? I've written about that, and you may find it if you'd like on my equinelawblog.com. If you're a seller and somebody purports to sign as an agent for a buyer, Make very clear who they're acting for. This is another detail that can be extremely important because disputes sometimes arise as to who had authority to sell the horse or to buy the horse. All you need to do is be clear and be specific. Next, contracts, of course, signed by anybody who's intoxicated or under serious medication, I write could be voidable. Fair to say they are voidable. So how do you determine that? Well, if you're contracting with somebody in your presence and they look like they just came out of the pub and you can smell the liquor on their breath, slurring of words, you get the idea. Don't contract with them. Don't let them ride your horse. And maybe they shouldn't even be driving home. These are the reasons that that contracts have been voidable. That would be underage signers and contracts signed by somebody who is claiming I didn't have the legal capacity to sign anything because of intoxication. Not a common issue, but it does occasionally come up. Let's shift gears now to the horse buyers. We've got a lot of individual horse owners listening in out there. So if you're a horse buyer, pay attention. How buyers can avoid equine-related legal disputes. That's what I'd like to focus on. And then we'll take some questions in a little bit. Well, let's start. This is an impulse purchase. Tridents, Kit Kat bars, candy bars. Buy those with no thought. Just pick it up, pay whatever it costs, and munch away. Perfect impulse purchase. We all buy them. But don't buy a horse as an impulse purchase. Do people really do that? Yes, they do. It seems that when people are at a show, they learn of a horse for sale. At an auction house, they find that there's a horse up for auction, and they really want it but haven't done their homework. They may find down the line that they've got a dispute on their hands. And this is a great way to avoid a dispute, which is to plan ahead and follow the suggestions that I'm going to offer to you right now. How can buyers avoid equine-related legal disputes? My number one suggestion to all buyers everywhere is if it's important to you, get it in writing. And now it's easier than ever. There was a time, of course, we didn't have computers everywhere. Look at this. Somebody's right next to their horse typing away. We've got access to computers where we can type something out, we can get it printed out, we can send it over to the other side for approval, for negotiation. We can work faster than we ever could now with contracts. We can get contracts put together so easily now than we could. But let's talk a little bit about getting it in writing. In my opinion, the mere process of entering into a sales contract is a great indicator of how sincere that horse seller is. Here's what I mean by that. The seller who promises to you that the horse has never been injured, lame, ill, never took a lame step. If that seller is willing to tell you that, that seller would be or should be willing to put it in writing if you ask the seller to do that. And if you're the buyer and the seller backs off and doesn't want to get that in writing, what does that tell you? If the seller won't put it in writing, it tells you that there probably is an issue, a problem, that the seller isn't telling you about. And the backing off of the seller might be reason for you, the buyer, to either back off or do a lot more due diligence on your part. But also, in your contract, think of some other details that you can put into it. For example, you really like that horse that the seller is selling, and perhaps you're maybe an older rider. Maybe you're somebody who's been out of the horse industry for a period of time. And now that you're older, the kids are away at school, and you want to get back in to horse ownership. You want a horse that's very easygoing, well-trained, bomb-proof, as some say. And you found a seller that has a horse just right for you. He meets all of your criteria, the seller says. If you're relying on statements of the seller about the horse being bomb-proof, well-trained, having years of experience as a trail horse, show horse, whatever, be willing to put that in writing, and of course be willing to demand that the seller sign off on it. What do I mean? I mean that if there are promises and statements that the seller is making, lawyers may consider these to be representations and warranties, put them in the contract. Don't hesitate to say that seller has represented to buyer that the horse has never been injured, ill, or lame, that horse has been ridden on trails for years without a problem, and go on and state in your contract the very details that the seller has told you that you're relying on. Get it in writing, get it in your contract, make it part of the transaction so that it's clear that the seller is promising in writing the very things that you relied upon that the horse about the horse. Other details before I move on to the next slide that you would want to get in writing, horse buyers, would be that perhaps the horse has never had any medications or has had no medications except for blank. Maybe the horse needs some bute once in a while. Find out why and when. Maybe the horse every once in a while colics, minor colics, and needs Banamine. Really, that may be a huge issue for you. That's called a medical colic to some. Why? Get some information on that. This may not be a horse that you want. Details like that can be critical. One other detail. Let's say you, the buyer, are about to make a major horse transaction. You're looking to buy a horse that is at least six figures, let's say, and the horse, as you intend, will be used for showing at the highest level of competition. Chances are you want to know if this horse, to get into performance shape, needs intra-articular joint injections. The horse that looks great today may have gotten in that condition because he's been injected. Put in your contract, buyers, whether the horse needs to receive joint injections. Is that a problem for you? Maybe not, but to some buyers it is. You can ask about it. You can ask to see the vet records. Get in writing information about the horse's history that you think is important. Let's move on to the next example and the next suggestion for buyers.
Ju-
Yes,
Julie, can we ask a question?
sure.
All right. So this is from the Auburn University Equine Science Student Group, and they're wondering if it's beneficial to have a sales contract notarized.
Good question. I get that once in a while. Do you need a contract notarized? Here is the purpose of a notary public. When we use the term notarized, that's kind of a verb. Notarized means that a notary public has been a witness to a party to the contract signing it. A notary public is somebody who is specially authorized, typically by the courts in the jurisdiction or by some official place, to administer oaths, to ask the signer to perhaps sometimes raise their hand that they are signing it freely, voluntarily, and affirming that. A notary can also serve as somebody who will witness and sign off that they saw the seller sign it. The seller was who he or she represented to be. The notary may have looked at his or her driver's license. That the seller seemed to be of signing the document freely and voluntarily. A notary is a special witness to a contract. Do you need it? I'm unaware personally of any states that demand you have a notary on a contract. When in doubt, certainly ask a lawyer in your state. But when would there be a circumstance when you wanted that protection of a notary public attesting that the person you're dealing with actually signed it and signed it freely? Well, I guess an example would be if the person is not in your presence but in another state, and you're not sure that Jane Doe is really the one who's entering into the contract. Maybe you want a notary public to say, yeah, that's Jane Doe because I was there, I witnessed her sign it, I saw her ID. If you feel that you need that comfort factor, that this person is who they represent themselves to be, sure, ask for a notary public. That would be an extra guarantee, if you will, an extra assurance that you're dealing with who you think you're dealing with. There can be exceptions we won't get into, which is a person with a fake ID calling themselves Jane Doe. But for the most part, on balance, my advice is you don't need a notary public. You can have a representation within the contract that the person signing it is who they say they are. You can have a warranty in the contract that the person signing it is certainly not only who they say they are, but that they own the horse, they can sell the horse, they have legal authority to enter into the contract. I think you get the idea. So a notary is an option. I don't use it in any of the contracts that I draft, but it's something to consider if you want that protection. Let's move on to another way that a buyer can avoid or try to avoid a equine sale dispute. Well, as it says, even with the seller's agent, get the seller's name and signature on the contract. And here's why. Plenty of buyers all over the country over the years have complained that somebody who sold them the horse as the seller's agent sold them the horse for a different price than the seller actually got. Quick example. There was a very well-known lawsuit, very popular, well, not popular, but it was notorious in Kentucky years ago by an heiress of the Johnson & Johnson family who sued a well-known saddlebred industry trainer. Why? Because she believed that the trainer was selling horses on her behalf and only remitting to her a small fraction of the amount that the seller was really getting, that the trainer was getting. These were her allegations. She also alleged that the trainer was buying horses for her, but telling her that the horse's real purchase price was much higher than it actually was. These were her allegations. The point here is that if you are buying from the seller's agent, know who you're dealing with and ask the seller to sign the contract, not only to send a message to the seller of what the purchase price is, but even more importantly, when that contract has promises, warranties that we've talked about, promises about the horse's history, you've got the seller's signature. That can be pretty important because that sales agent who may have the horse at his or her barn, who's showing the horse off to you, may only have had the horse for a couple of weeks. And you, the buyer, are relying on a lot of promises. So when that trainer, seller, dealer says, I'm the agent and I'm promising that this horse has never been injured, ill, lame, what does that mean? When you get the seller's signature on the contract and the seller makes these promises, perhaps in addition to the agent, you now have a promise that you can believe in because it's coming from somebody who truly owns the horse. So for these reasons, among others, if you're the buyer, demand that the seller's name be on the contract and of course that the seller sign. Sure, the agent can sign too. Get the seller's name. And speaking of that, tucking into a little comment into this, sometimes the seller's agent expects a nice commission. Be specific in your contract about who pays that commission. And if you know that there's a seller's agent, you can put in the contract that the seller agrees to pay the seller's agent commission. Maybe even list who the agent is, or broaden it further and say that if there are others who are entitled to commissions from the seller or as a result of the sale, the other party pays it. If you're the buyer, then make the seller pay any commissions that may be asserted by a third party. The seller may want you to pay the commissions, but be specific. That's where it's important to put the seller and the agent on as the signer of the contract. Another example that really merits discussion. I think a lot of you on this webinar have enough information about the industry to know that it makes sense to vet the horse before buying. Sure, you can rely on the promises in the ad where the seller says 100% sound to a degree. You can trust it, but verify it. Get an independent vet. You've probably heard of buyers who let the seller pick the pre-purchase exam vet. And if you're like me, you're probably cringing at that thought. You would want, as the buyer, an independent vet who doesn't have a relationship with the seller, preferably doesn't even know the horse. Years ago, I worked on an equine sale dispute. It was a lawsuit in the Midwest, it wasn't my state, where a very well-known world champion horse was being sold. It was being sold by a husband and wife trainer team. They were acting as sales agents for their client. What was interesting about that? Here's what. The horse had been denerved. Because of the rigors of his showing and because of his age, he was denerved, and interestingly, nobody represented to the buyer about this history, which I think to most buyers would be a very important fact. What does that have to do with vets? Here's what it was. One of the trainers in the husband-wife team was primarily responsible for the care, training, vet attention, farrier attention of this particular horse. The other trainer was kind of out of the loop. That trainer did other types of work on the farm. So when it came time to arrange the sale, the buyers actually let the other trainer, and it was interesting how the other trainer who was not familiar with the horse became involved in the sale. That trainer who was not involved hired a vet, and the vet was supposedly unfamiliar with the horse, but the vet didn't even pick up that the horse had neurectomy scars. The horse had scars that the vet didn't see. There could be an issue about which trainer knew, which one didn't know, but the point was the buyer spent a lot of money for this world champion only to discover that the horse had been denerved. That generated some pretty serious problems down the line. The lawsuit was followed. And of course the lawsuit was expensive, time-consuming for everybody. How can you avoid it? Well, you can try to avoid it as a buyer by hiring an independent vet that you pick, a vet who doesn't know anything about the horse. Could the problem have occurred that I discussed with you, the one about this world champion, if the buyer picked the vet? It's possible. I suspect that the trainer may have picked a vet who perhaps had a history of not recognizing these problems. But if you're the buyer, make sure it's a vet who doesn't know anything about the horse. You select that vet yourself. And if you can't be there during the pre-purchase exam, you're busy, you're out of town, consider having the pre-purchase exam videotaped so you can watch it later. If you would like your local vet to weigh in and the horse is out of state, consider having your local vet view the x-rays before you make the purchase. There are plenty of ways that you, the buyer, can be comfortable with the sale. You can be involved in selection of who does the exam, and you can make sure that everything is done according to terms that are acceptable to you. Make the choice of your vet and make the contract clear that you have a certain amount of time to reject the sale, to conclude the sale, based upon your personal satisfaction with the results of the exam. Let's move on. Get a drug screen. I think it goes without saying, don't buy the horse until you receive the results of the drug screen. Don't jump in only to find that the horse has been at your place for a day. The results come back and you're extremely unhappy. I have to caution you that there are some trainers out there in the horse industry who are proud of the fact that they use medications and substances that don't get tested. They don't pick up. Some of these are herbal substances. Fair to say that you take that risk, that the seller may be using a substance on that horse that doesn't show up in a drug screen. But based on current technology, there's a lot that can be picked up. It's worth the shot, and it's certainly important. So my recommendation to all buyers is get the drug screen and hold off on the sale until the results come in. Next, this is a bit of a controversial suggestion, but I strongly suggest for buyers, especially those who don't have experience with horse ownership or who have been out of the industry, consider finding a respected equine professional to come and check out the horse, watch you ride the horse, watch you handle the horse, and evaluate it for suitability. Interestingly, there's a website out there. It's a website that a seller uses. I will not mention names. It's a seller actually that my client hired me to sue a few years ago. On that particular seller's website, it says, don't bring your trainer to check out our horses before you buy. This seller specifically did not want this suggestion, which is suggestion number 5, to be followed. I wonder why. If you're the buyer, getting the opinion of somebody who you trust in the industry, somebody who you believe has your interests at hand, is a great idea, because there may be details that you simply are missing because you're so infatuated with this horse. He's the right color, he's the right breed, he just looks the part. The independent professional, if you find the right one, can help tell you that maybe this is too much horse for you. Maybe this isn't a good fit because of whatever details. The key is to find somebody who you respect, somebody who you truly believe will be looking out for your interests, and somebody who's not looking to stop the sale so that they can find a horse for you and make the commission. Conclusion, couple of quick points. Buyer beware? Not necessarily. Buyers have rights, buyers have sued sellers, and buyers will continue to look at their legal options when they get into disputes with sellers. Better still, try and avoid the disputes. Quick comment, because the topic today did involve fraud. I want you to be aware before we get to questions, this is what fraud is as a general matter. Fraud in the horse industry or in any industry is where the seller made a material misrepresentation about what was sold. That representation was false. Let's stop there. The example of the horse that's advertised as never having taken a lame step, when in actuality he's been very lame, he's been laid up. That is a material representation to most buyers, and of course it would be false. You're getting there. You're getting toward the definition of fraud now. Let's continue. When the seller made it, he or she knew it was false or made it recklessly without any knowledge of its truth and as a positive assertion. I gave you the example of the case that I tried, and we won, where the seller talked about the horse being sound and ready to show today, when the seller really did make it recklessly. On cross-examination, the seller admitted that they really didn't know all that much about the horse other than he rode okay. It was not show ready. That was a statement made recklessly. Now we're still part of the way on fraud. Next, the seller made it with the intention of inducing the buyer to act. If you make a statement of the horse having no vices, no bad habits, never being lame, chances are you're doing that to draw in an interested buyer. These are important facts. Next, the buyer acted in reliance upon the seller's representation. Hey sellers, If you're out there and you're concerned about this, you're doing everything right, but you're worried, how do I avoid liability for sales fraud? Encourage that buyer to make as many independent exams as they want of that horse within a certain period of time. Let them go and have vet exams done. Let them have an equine professional examine the horse. In order to do that, you'll have to give them a certain amount of time, of course, but it also hopefully kills the element of reliance, because maybe the buyer isn't relying on you, seller, if you've been truthful. They're relying on the advice of their vet, their professional, somebody else. Next, of course, the buyer suffered damages, which is to say losses. As a result, this is fraud. Quick comment too, there are state laws involving sales. I just want you to be aware of them. This is not a law discussion for law students, but this is a discussion about the rights that buyers have. There are state consumer protection laws, very powerful, because some of them look at the amount the buyer lost and triple that amount, plus give the buyer back their legal fees. That's pretty powerful. Some states would include, for example, Texas. They have a deceptive trade practice law that has been used in the setting of horse sales. Same with my state of Michigan. Most states do. And in many states, you can invoke these laws unless you're a business, and sometimes these laws don't apply. Uniform Commercial Code, that would be if warranties were made, for example, in regard to the horse, and you believe that they were false. Seller disclosure laws, I touched on them briefly. I touched on the fact that 3 states so far have laws requiring the seller to make specific disclosures in writing. These are the states. There are other laws as well. Well, Gwen, I turn the floor over to questions, and of course, Gwen, you're going to have to read them because I can't see them on my window of my computer here.
All right, well, I can definitely do that for you. So we have one question so far that came up a little bit earlier in the presentation. And what happened here is this person recently bought a quarter horse last May. The horse came with a signed guarantee that he was sound in the legs. A few months later, he was diagnosed with wobblers. The vet said I bought him this way, as it is not something that a horse just develops. Because of this, he cannot feel his legs, so he stumbles and falls. The actual problem is is a pinched spinal column, but it makes him unsound in the legs. Do I have a case? When I talked to the original owners, they basically said, too bad.
That's an interesting question, and that raises a question about the terms of the contract, because I know I talked and harped on it at great length the importance of a thorough written contract where all of your assumptions are clear. In this case, the buyer got a guarantee of soundness, but it limits it to legs. What does that mean? Unfortunately for this buyer, I think you're looking at a problem because the contract is not completely clear as to how far the guarantee goes. And it may very well be that because the horse can't feel its legs and it stumbles, that it has that there's been a violation of that warranty of soundness, or that the guarantee rather can be invoked. But the difficulty and the complexity is really based on the fact that the contract is so limited and so narrow. So for you, the one who bought the quarter horse last year, you've got a few things to consider. First, talk to a lawyer in your state about whether you have any rights. Talk to a lawyer in your state about whether, regardless of this guarantee, whether there's a basis for fraud. It's hard to say because you'd have to order up the vet records, and you're not going to get them without the sellers giving that to you. But you've got a number of things to consider. Also, the statute of limitations. This was a sale last year. Must you put the seller on notice to invoke your rights? Keep in mind that there are a variety of laws to consider. So your checklist for your lawyer would be, number one, what does the contract mean, and can I invoke this guarantee and perhaps call this contract off? The lawyer will look at the contract and determine it. Number two, if the contract is, as lawyers say, vague or ambiguous, what's the lawyer's opinion on your chances of fighting the contract to be able to accomplish what you want? Number three, are you duty bound to give notice to the seller of your concerns in regard to this horse? With certain laws, certain breach of warranty laws, you need to give notice to the seller, and you need to do it soon. Uh, Beyond that, the lawyer can give you more advice, but it really depends on the terms of the contract that you signed. And this one, I'm afraid, is not all that clear. Do we have another question, Gwen?
Okay, we have a couple people that are typing. Joanne and Robin, I see you're typing up some questions. Maybe while you're typing, we'll go to kind of one we had talked about previously here, and I'll also put this in the chat. But the question is, what do you think about trial periods in equine sales?
Trial periods are really a mixed bag. The best horse I ever owned, I bought on a trial period basis, so I liked them because they suited my purposes. But from the standpoint of the seller, I couldn't be more concerned than I am about trial periods. And here's why. If the trial period allows the buyer to take the horse off premises and do whatever the buyer likes with the horse and then return it to you if the buyer's not happy, you've got an even more serious problem than the problem of injury or illness to your horse. You've got a problem of liability. And chances are, if you're like most horse sellers, you don't have liability insurance that's designed to follow the horse wherever it goes. You could if you have a policy of personal horse owners liability insurance, for example, but liability is a huge concern because as the buyer's riding and testing and working with the horse and letting people near it, you have no control over what the buyer's doing. And as the owner of the horse, which you are during a trial period, you are fair game, unfortunately, for being targeted with litigation. So the liability concern is my biggest concern, and the fact that so few people have liability insurance. Sure, you could give the buyer a liability release to sign if the buyer is of legal age and the release is properly worded, but that doesn't go very far either, because when a third party gets injured from the horse, they didn't sign your release. And you may have, I'm getting complex here and complicated, but you may have an indemnification clause in your release where that would-be buyer says, if any third party gets injured, I will release you. I will indemnify you, the seller. I will hold you harmless. I'll pay your fees. Really, how can you be sure that that will happen? Because the would-be buyer can promise you all kinds of things if you get sued by someone, but when it comes down to it, is the buyer financially able to pay your legal fees? Maybe not. So you've got a promise from that buyer to protect you that may not be worth even the paper that it's written on. So liability is my biggest concern. Then, of course, there's the concern about the care of the horse, the welfare of the horse. In my opinion, if you're interested in a trial period, if you're really interested, keep the horse on your property and let the buyer come and work with the horse on terms that you find acceptable. Of course, make sure the buyer signs a release, and of course, make sure that the buyer can only do with that horse what you allow that buyer to do. Keep those controls, and I think I'd be much more comfortable with it. Overall, my advice, avoid trial periods.
Okay, we've got another question here from Joanne. She asks, is it wise to have a lawyer who specializes in equine law formulate your contract with a potential seller to avoid some of the mistakes that you have identified?
I think that's a really good point, and I would say yes. The problem is that there are very few lawyers around the country who truly practice equine law. It's hard to find them. Google searches can find them. If you can find a lawyer who has the right expertise in your state, I think that's a great start. It may very well be, on the other hand, that you can't find a lawyer with proper experience in your own state. So what do? Option number one, you can look for lawyers out of state, but understand that if they draft a document for you, they can't practice law without a license in another state, so that lawyer would probably do something for you that you would need to have vetted by and approved by a lawyer in your state. That can be expensive, and not a lot of people want to do that, but it is an option available to you because there are lawyers around the country that can help you and can draft a document for you, uh, subject to the ethical restrictions that they can't practice in another state that they're not licensed in. Or you can have your lawyer work with that out-of-state lawyer. So the out-of-state lawyer, who's the specialist in equine law, can help your lawyer draft the document, or even draft it subject to your lawyer tweaking, presenting, and working with. So these are options available to you, but I think it's great to find a lawyer with expertise in equine law if you can, because it's with that knowledge of the industry and knowledge of horses that the lawyer can put in all of the protections, hopefully all of them, that are best for you. The concern, for example, about the independent vet, the representations that you, if you're the buyer, would need, such as the representations specifically about the horse's condition. These are just a few things, and if you don't practice equine law, you may not be privy to them and you may miss them. Moving on, next question.
Okay, our next question is from Chris. Should a potential buyer sign a liability release before riding a sales horse? And what if they are a minor?
Aha! Two questions. Let's start with liability releases before riding or testing out a horse. The fact is, and I know this because I follow the law of releases very, very carefully, most states around the country have shown, the courts in those states that is, have shown a willingness to enforce releases of liability when the documents are properly drafted and properly signed, which means children certainly can't sign a release. That document would be voidable from the beginning. And there's even been case law. One case, I believe, from Tennessee, a 14-year-old signed a release and it was stricken. I think that was Smokey versus McRae as the case. You need somebody of legal age to sign it, but the document also needs to have all of the language that the state is particularly concerned about for inclusion in it. What do I mean by that? I mean that states differ all over the country as to what goes in a liability release. A quick example. Thanks to equine activity liability laws, releases are actually more specialized than ever before. If you're in Arizona, your equine liability law even tells you here's what needs to go in a release, among other language. If you're in the state of Virginia, Virginia wants the release to refer to intrinsic risks. If you're in Ohio, your equine liability law requires, in addition to all the usual release language, a very specific list of inherent risks. You get the idea here. Quick example, and then we'll move on to the next question. I worked on a lawsuit years ago in California where a riding instructor took a release that she just found somewhere off the internet, not sure where she got it from. It was in a chat room, whatever, and she put it to use. But the problem was, this was an older case. The state of the law in California at the time for releases required that releases include the word negligence. What do I mean by that? I mean that the state courts said at the time, for a release to be able to release away claims of negligence, the release needed to say that the signer was releasing the stable owner trainer from liability for its ordinary negligence. But the release didn't do that because the particular trainer just found the document and it didn't conform to the state law. Well, the most unthinkable accident occurred. It was a severe closed head injury of a student in a lesson. So severe that a 47-year-old mother of teenage daughters was rendered a 6-year-old, if not younger, mentally for the rest of her life. Very severe accident. Surgeries occurred to this woman. I believe she was institutionalized after because of a variety of complications. And guess what? The release failed. It didn't help this instructor. So the state-by-state variations are critical in releases. So I can't emphasize enough, if you're going to use them, and I strongly recommend that you do, since most states are welcoming of them, make sure they comply with the state law.
Okay, so the next question kind of goes back to the question about trial periods when going to look at a horse. And the question is from the Auburn University Group, what about a lease with option to buy in place of a trial period?
Interesting question. Leases with option to buy are becoming, I think, more frequent. Let me also go back and finish something that I didn't quite answer in the last question. There's been a disagreement among the states as to whether a parent can legally release the claim of his or her minor child. So I want you to be aware, if you're listening in on this call, that you may have a parent sign off on a release for the child, but understand that there is a difference. The states simply cannot agree amongst themselves as to whether that will stick. Some states are okay with it, Ohio being one based on a case. Other states are not. Colorado was against it from the Supreme Court, but a law got passed permitting it to be done. Let's get to the question of leases with option to buy. Not a bad idea, but a lot of the very same concerns that I expressed before with regard to trial periods apply with equal force in leases. Quick example, liability. If you lease a horse to someone else, you're still the owner. And as the owner, you're still potentially on the firing line if somebody gets injured from that horse. Sure, the lessee who rode the horse fell off and then the horse ran into the road and hurt somebody. The lessee could be a target, but you're the owner of the horse. Somebody will find, I guarantee you, a clever way to include you in that lawsuit. So the lease with option to buy is certainly another way to document the transaction. You can be specific in what the lessee or if it's a trial period, the prospective buyer can do, but you still haven't eliminated the problem. So if you're interested in a lease with option to buy, remember that you, the lessor, would be wise to have liability insurance, just as if you were doing a trial period, and you'd want a very specific contract that specifies the use, the restrictions, and numerous other details with respect to the horse. Oh, and then there's another problem. Regardless of whether it's a trial period or a lease, what happens if the horse becomes injured, lame, or ill during the term of the lease or even the trial period? Who pays for the ongoing care if this becomes a huge problem with the horse? Who pays for the colic surgery if the horse colics on the lessee or the trial period person's watch? These are details, and these are details that a contract can specify. Gwen, do we have time for any more questions?
I think we can keep going for a few minutes if that's okay with you. We've got 1, 2, 3 questions here waiting.
Okay.
All right, so the next question is from Lisa. Okay, I have a horse that we may sell that has a problem with being clipped, especially around the muzzle. It may be possible that someone with more experience would be able to work on it and get her through it. What is the best way to represent this in a sale?
Well, that could be, when you say a problem being clipped, I can visualize almost anything. The horse rearing up, perhaps in cross ties, rearing up and falling over, all kinds of things, or the horse just becoming so enraged that it rears and strikes, all kinds of things. Or it could be just a horse who doesn't like it, and he's a steady Eddie, wonderful horse, but he's going to pin his ears, maybe try and bite. It's a matter of degree, but honesty is absolutely the best policy. Because if you know that the buyer will be clipping this horse, you know the buyer plans to show the horse, the buyer's going to find out. So why not explain it? Why not disclose it? And you can avoid all sorts of issues from the buyer who's claiming that it was a material thing and you didn't say it. Better to say it. Now, there are other people who would recommend that you, the seller, not mention it. Because after all, if the buyer didn't ask you, how is he being clipped? You're not defrauding anybody. You're not hiding anything. You weren't asked. I can understand that line of reasoning. And that line of reasoning, some may think, is equally valid. On balance, if you want to be absolutely sure, seller, that you won't have a disgruntled buyer who thinks that you're dishonest and who will say bad things about you from their experience, or worse, a buyer who will think that it was an important detail that you concealed, better to just let the buyer know, and let the chips fall where they may. Or find a buyer who you don't think will ever be clipping the horse. Take a risk on that, but better to be open about it, in my opinion.
Thank you. Our next question is from Robin. And her question is, how pricey is it usually for buyers to have the horse examined by a vet before purchase? If they plan on looking at a lot of horses before they purchase one, they may not want to spend so much money in having them all pre-examined by a vet. Would it be their loss for purchasing a horse that turned out to be lame for failure to have it examined? And then a follow-up question for that is, asked down here towards the end is, are there any situations where having a pre-purchase exam does not make sense?
Good questions, and I'll try to answer them briefly. Really, the decision of whether to have a pre-purchase exam done, if you're the buyer, is a very personal decision. And a lot of it depends on the price that you're paying, the use you have in mind. There are so many factors that go in. Some buyers just go on faith. If you know who you're dealing with and you really think that you can trust that seller when the seller tells you this horse has never been ill or whatever, you can take that to the bank, well then maybe you want to buy the horse. But what about the horse that has never manifested any lameness or any problems, but it's just waiting to happen? And it's going to happen when the horse is on your watch. It's because of those risks that I think it makes sense to make that investment in a pre-purchase exam. But the question is, how much do you spend? And that's another personal decision. If you're going to spend obviously a lot of money, I've got a client who is in the process now of purchasing a horse for about $150,000. That particular client had very extensive exams done. Another client bought a horse last year for $500,000. They had exams done that were very extensive and very expensive. It really depends on your comfort factor, but better to know. So what can you have the vet do? You can talk with the vet about his or her concerns. Should you, for example, x-ray the hocks? Should you focus on the fetlocks? Should you focus on the knees? What parts of the horse does the vet think it might be a wise idea to focus on? Do that if you're concerned about controlling costs. The drug screen, if you're going to have a pre-purchase exam, why not? And of course, the stress tests and all the other tests that the vet does. You can discuss how to do that on a budget, but realize that when you forego part of the exam, you are accepting a certain degree of risk because there could be problems that the horse has never shown that are just out there. So again, it's a very, very personal decision as to how you do it and whether you even go through it. I can also mention briefly, I know we have a couple of other questions and we're running up on time. There have been plenty of buyers who are dissatisfied with the pre-purchase exam and plenty of buyers who have actually sued vets for veterinary malpractice by missing things that they thought, the buyers thought were important. That's an issue too, it's a separate issue. But if you're the buyer, I think the smart money is getting as much information as you reasonably can and draw the line on expense depending on your comfort factor and your budget. More questions? How are we doing on time?
Yep, I think we just have a couple more here. And I do want to also mention that in the chat, Chris Skelly posted an article from eExtension on pre-purchase exams. So that may be another link that you all may want to look at. Our next question is from Sally. Her question is about right of first refusal between states. How enforceable are they? Are you required to sell back a horse at set price even if price quadrupled? I just purchased a horse, traveled 8 hours, met the vet, agreed that I will give the right of first refusal, which we discussed, but we did not discuss at what price. She insisted at the purchase price. I paid in the 5 figures for the said horse. I signed it because I wanted to go home. I did not plan on selling the horse, but I bought an untrained horse. After several show seasons, the horse will be worth much more. And that she has an additional comment here that she's primarily here because she purchased a horse in the spring. He was advertised in writing on several websites as a 7-year-old horse. I specifically told buyer I wanted a 7 to 8-year-old horse. It turns out the horse just turned 4, which explained his crow hopping issues. She found pictures and documentation on social media contradicting his age. She insisted that the horse was 7, even though 2 years ago she had threads that said he was an unbroken baby. She also admitted it via email. I don't think she realized that email was legal documentation. I know this was fraud and resold the horse to a training facility at a $2,000 loss. So once again, the question kind of coming back around was about right of first refusal between states and how enforceable they are.
I can tell you from experience that I've received calls from people who have signed contracts with rights of first refusal. We'll get to the details on those documents in a moment. But the seller, for example, sold a horse where the buyer gave the right of first refusal, and the horse was never, the right of first refusal was violated. The person in possession of the horse, the buyer, never gave the seller the offer years later to buy back the horse. The seller wanted that option and learned that the horse had already been through a couple of different owners. So the first comment I offer, unfortunately, is there are plenty of buyers who simply ignore the rights of first refusal. They forget about it. Years pass. They don't even remember what the contract says. They may not even have the contract. So now the buyer, or rather the seller, who wants that horse back, is left with evaluating legal options, none of which are easy, quick, or cheap. So the first caution about rights of first refusal is that a lot of times they simply don't get followed regardless. We'll talk about the legalities perhaps in another webinar. Let's get now to the terminology for a right of first refusal. They all differ. Rights of first refusal can be as vague as one as was described here, where it sounds like the seller has the right to purchase the horse, if the buyer wants to sell it, at the very same price. Buyer, you apparently agreed to it. You wanted to move on, get out of there. Nobody put a gun to your head and forced you to sign that contract with a right of first refusal. Nobody put you under any kind of duress to accept that contract with that provision. So you accepted it, and frankly, it sounds like you're bound by it. So the question will be the way that right of first refusal is worded so that you know how to give that right to the seller. Or another question is, do you want to show that contract to a lawyer to determine if the right of first refusal is even binding? After all, you ask, the seller's in another state. Is it binding on someone in another state? I suspect that if the right of first refusal is properly worded and the contract is overall valid, it is binding on somebody in another state. But you'll know if you get an opinion from a lawyer who's looked at the contract to determine how valid it is. But because the contract, it seems, has this clause in it, because the circumstances were that it was validly signed, there wasn't any duress, it could have been stricken out, it could have been modified. I'm a little bit concerned, horse owner here, that you may be obligated to let the seller weigh in. But again, talk to a lawyer who can read that contract and give you more specific advice. Finally, on rights of first refusal, anybody on this call who is considering either drafting a right of first refusal clause when you're selling a horse and you want to give that buyer an obligation to come back to you before they sell it, remember that there are so many details that make a right of first refusal agreement workable. Details can be that the seller has the right to buy at the same price, which is the example we heard in the question posed. That's potentially fair or not fair, because the horse could be shown and improve in its value, but you, the new owner, may have to sell the horse that way. Or, on the other hand, the horse could be just showing signs of age. He's getting old. He's getting arthritic. The horse is worth less than what you paid. Well, maybe it's a nice idea to offer it to the seller at that same price and see if the seller bites. The seller may want that horse, and it may work to your financial advantage. Devil's in the details on a right of first refusal. You can specify a price, you can specify a time frame, but nevertheless, if you have questions about your rights of first refusal and how to draft them, talk to a lawyer, because these can be very complicated contract provisions. Where are we now, Gwen? Another question, or do we wrap up?
Yeah, let's just take one last question, and then I think we'll wrap it up. Our last question is from Joanne. When do you buy insurance on a horse to reduce risk?
That's a great question. The question or the issue of whether insurance is right for you is one that varies with the interests of the owner of the horse, the amount of money the owner wants to spend. Suffice it to say that if you purchase a policy of equine insurance on your horse, you have a policy that is in some ways comparable to life insurance on a human, but frankly, it's not exactly the same thing. Because under certain circumstances, an equine insurance policy can allow you to euthanize the horse and still collect. Life insurance policies, well, we won't talk about that. Let's talk about when it's right to buy it and time-wise when it's best. As a matter of law, and as a matter of contract law, and as a matter of equine insurance policy language, you can only purchase insurance on a horse that you own. If you are the lessee of a horse, you're not the owner of the horse, but many insurance companies will let you let you insure the horse along with the owner, the lessor. So the horse is insured in both names. What happens if there's a claim and the horse has been put down? What happens is the company will write a jointly payable check, and the two of you divvy up what, if anything, each person gets. If you're making an offer to buy a horse, and you want that policy in place for when he goes on the trailer and comes to you, the insurance company will only issue that policy when you can show that the purchase agreement has been executed and it's complete, because then you've got title to the horse, you've got ownership of the horse, and you've got an insurable interest. So when is it right to get the insurance? If you want to protect your interests, your financial interests, because you'll get a payout presumably equal to the purchase price of the horse, purchase it just before the horse gets on that trailer and comes back to you. If the horse encounters shipping fever or a complication. I worked on a case once. It was a very interesting lawsuit of a horse we believe was bitten by a brown recluse spider, actually a few of them. This horse sustained some bizarre injuries to one of his legs. But the insurance was in place on that horse, so when he had to be euthanized because all options failed from what we believe were multiple spider bites on the leg, the policy was there for the new buyer, and the buyer was able to work with the company and collect on that policy. So consider doing it when you are making that purchase as a way of protecting your investment. The other benefit of mortality insurance, as many of you know, is along with that insurance, these insurance companies have been offering for years an endorsement, major medical endorsement, which might help defray the cost of colic surgery or substantial veterinary fees. Not a bad thing to have. One other add-on to that insurance, which is worth considering. We talked about personal horse owners liability insurance a little while ago. Some equine mortality insurance companies may offer to you the option to purchase a personal horse owner's liability insurance policy. It's not equine insurance, it's a different kind of insurance, but they'll make that available to you for an extra cost, which will protect you from liability. So when the horse is on the trailer coming from California to the state of Maine, and he's stepping out of the trailer to just kind of walk around, and he breaks loose and starts running into cars and people, you've got that personal horse owner's liability policy hopefully in place and hopefully working. Any other questions, or are we calling it a day?
I think we'll call it a day. So let's wrap this up a little bit. First of all, we'd like to thank Julie for presenting tonight. We really appreciate your insight into this topic and really appreciate all the knowledge that you've given to us. And of course, we'd like to thank all of our participants tonight as well for your questions and interaction here this evening as well. You all will receive an email with an invitation to complete an online survey, a really short survey about the webcast tonight to give us some feedback. And so you'll receive that in about 1 to 2 days. But if you'd like to just quickly take it tonight, you can do that as well. You can click on the URL here up on the screen, or I'll actually put it here in the chat box as well. So if you go to that link, you can take the survey right now if you would like. And once again, we would just really appreciate your feedback as we continue to have these webcasts and to improve some of our processes and so forth. Our next webcast that we have in November, we don't have a set date yet, but we can tell you the topic. We are going to be talking about horse rescues. And so be looking for more information on this as we finalize it on our Facebook page and up on our website. And as soon as we have that information, we'll be putting it up there. It, of course, will also be in our November eTips newsletter as well. Also, one thing I'd like to add is on the lower right hand side of the screen, you see an Ask an Expert icon, and there's a URL right underneath that you can click on as well. This is a way for you to ask questions of equine extension specialists throughout the country. So you can go here and you could ask a question on any topic relating to equine. So just a great resource for all of you to have. Lastly, please remember that this webcast was recorded and we'll be uploading it to our website tomorrow. And feel free to send us any comments or suggestions that you might have to info@myhorseuniversity.com. And with that, I'd like to thank everyone and wish you all a great evening.